What if the biggest fight in this courtroom battle isn't about what was said, but about who has to answer questions under oath? A new legal showdown is unfolding involving former First Lady Melania Trump, and at the center of it all, claims of defamation, alleged Epstein-era social connections, and a legal maneuver that could determine whether sworn testimony ever happens. Let's break this down carefully. This story begins with a threat. Michael Wolff, known for writing books about Donald Trump and his orbit, made public comments referencing Melania Trump's past social proximity to Jeffrey Epstein during the New York social scene of the 1990s. Importantly, Wolff has said he did not accuse Melania Trump of criminal wrongdoing, but her legal team viewed his statements as defamatory. According to reports, her attorneys sent a demand letter seeking a retraction and allegedly warning of a potential lawsuit seeking damages in excess of $1 billion. Instead of retracting, Wolff filed suit first. His claim argues that the legal threat itself amounted to an improper attempt to silence speech, what's commonly referred to as a SLAPP, or strategic lawsuit against public participation. These types of actions are often criticized as legal intimidation tactics designed to discourage reporting or commentary on matters of public concern. So now, rather than Melania Trump suing Wolff, Wolff is suing over the threat of being sued. That's when the procedural chess match began. The case was originally filed in New York State Court, but Melania Trump's legal team removed it to federal court, specifically the U.S. District Court for the Southern District of New York. Removal to federal court is allowed under certain conditions, including something called diversity jurisdiction. That requires the parties to be residents of different states. And this is where things get interesting. Melania Trump's attorneys assert that she is a resident of Florida. If true, that could justify federal jurisdiction. But Wolff's side has reportedly questioned that claim, pointing to ties to New York, including time spent at Trump Tower. In legal terms, what matters isn't where someone visits. It's domicile, the place a person intends to remain permanently. If the court determines she is domiciled in New York, the case could be sent back to state court. And here's the twist. Arguing over residency could trigger what's called jurisdictional discovery, meaning sworn statements or document production just to determine where she actually lives. In other words, a move that critics say is designed to avoid deeper discovery could potentially open the door to discovery on a different issue. After removing the case to federal court, Melania Trump's team also sought to transfer the case to Florida. Venue transfer motions are legal and common. Attorneys argue for them when they believe another court is more convenient or appropriate. But critics, including commentary from Mycellus, frame the move differently. They suggest it could slow the case down, potentially delay depositions, potentially postpone accountability. To be clear, procedural strategy is a normal part of litigation. Every experienced legal team uses it. The question isn't whether tactics are being used. The question is whether they succeed. Melania Trump's attorneys have also reportedly filed a motion to dismiss the lawsuit altogether. A motion to dismiss argues that even if the plaintiff's allegations are taken as true, the case still fails as a matter of law. If granted, the case could end before any discovery happens. If denied, the case moves forward, and that's where things could escalate, because discovery means documents, emails, communications, and possibly depositions under oath. Depositions carry legal risk. They're sworn testimony, they create a record, and in high-profile political cases, they generate headlines. Now let's talk about defamation. For a defamation claim to succeed, a plaintiff must generally prove a false statement of fact, publication to a third party, fault, and damages. But when the plaintiff is a public figure, as Melania Trump unquestionably is, the legal standard is even higher. She would need to prove actual malice. That means showing the statement was made knowing it was false or with reckless disregard for whether it was true. That's a difficult bar. It's designed to protect speech about public officials and public figures. This legal standard has shaped American media law for decades. And it's one reason defamation lawsuits involving public figures are so challenging. The Epstein context adds another layer. Epstein's past associations with powerful figures have been under intense scrutiny. Being socially adjacent to Epstein during the height of his social prominence does not equate to criminal wrongdoing. But in today's political climate, even historical social overlap can become explosive. The lawsuit does not accuse Melania Trump of criminal conduct. It centers on reputational harm and whether commentary crossed into defamation. But because Epstein's name carries enormous weight, the controversy amplifies instantly. There's also broader context here. Members of the Trump family, including Donald Trump, have faced multiple legal battles in recent years. Melania Trump has reportedly threatened litigation in other situations as well, including disputes involving Hunter Biden. Supporters argue that these actions represent strong defense against false claims. Critics argue they reflect aggressive legal deterrence. Ultimately, courts, not commentators, decide the outcome. So what happens next? There are several possibilities. The court could grant the motion to dismiss. The case could be remanded back to New York State Court. The transfer to Florida could be approved, or the case could proceed into discovery. Each path carries consequences. Each shapes whether sworn testimony becomes part of the record. And that's why this procedural battle matters. Because sometimes the most consequential fights in litigation aren't about what was said. They're about where the case is heard, who has jurisdiction, and whether discovery ever happens. For now, the court's rulings will determine the direction. The narrative battle continues in the media, but the legal battle continues in filings and motions, not headlines. This case touches on free speech, on defamation standards, on anti-SLAPP protections, on jurisdictional law, and on how public figures defend their reputations in a polarized era. Whether this ends in dismissal, transfer, or deposition, it is already shaping conversations about legal strategy and political accountability. And if you want to understand how power, media, and the courtroom intersect in real time, stay tuned, because the next ruling could change everything. While the procedural motions work their way through the court system, the implications of this dispute extend well beyond the immediate parties involved. At its core, this case sits at the intersection of reputation, political speech, and procedural law. It highlights how modern litigation, especially involving public figures, often begins long before a jury ever hears evidence. The earliest battles are frequently over venue, jurisdiction, and whether the lawsuit should exist at all. For Melania Trump, the legal objective appears clear: challenge the viability of the case at every threshold stage. Motions to dismiss, jurisdictional arguments, and venue transfer requests are all legitimate legal tools. When used successfully, they can end litigation quickly or move it to a forum viewed as more favorable. For Michael Wolff, the strategy appears equally clear: keep the case alive long enough to enter discovery. Discovery is where lawsuits become consequential. It is where internal communications can be requested. It is where sworn depositions can occur. It is where disputes over private knowledge become part of the evidentiary record. This divergence in legal strategy underscores the broader tension at play. From a procedural standpoint, federal courts apply structured tests when evaluating removal and transfer motions. Judges examine statutory requirements, prior case law, and factual submissions. They do not evaluate political optics. They assess legal sufficiency. In diversity jurisdiction disputes, courts often look at objective evidence of domicile. That may include voter registration, driver's license records, tax filings, property ownership, and statements of intent. The burden typically falls on the party invoking federal jurisdiction to demonstrate that it exists. If the court concludes that domicile has not been adequately established outside New York, the case could be sent back to state court. If domicile is confirmed in Florida, the federal court retains jurisdiction, and the venue transfer motion becomes the next major decision point. Venue transfer motions involve a different set of factors. Courts examine convenience for witnesses, access to evidence, local interest in the dispute, and the interests of justice. These analyses are often fact-specific and can hinge on subtle distinctions. Observers have noted that high-profile litigants frequently prefer forums perceived as more favorable. However, judges are tasked with ensuring that transfers are grounded in statutory criteria rather than speculation. Parallel to these jurisdictional battles, the motion to dismiss carries its own legal weight. A successful motion to dismiss would mean the court has determined that Wolff's claims fail as a matter of law. In anti-SLAPP contexts, courts sometimes examine whether the speech at issue concerns matters of public interest and whether the plaintiff can demonstrate a likelihood of prevailing. New York's anti-SLAPP statute was strengthened in recent years, broadening protections for speech related to public issues. If the court finds that the challenged speech falls squarely within those protections, dismissal could follow. If the court finds that the anti-SLAPP protections do not apply or that factual disputes preclude early dismissal, the case would proceed. Should the case advance to discovery, the tone and stakes would shift significantly. Discovery can be extensive. Parties may request communications, internal memoranda, drafts, correspondence with publishers, and communications with third parties. Privilege disputes often arise, requiring judicial intervention. Depositions, in particular, can become focal points in politically sensitive litigation. They are conducted under oath, recorded by court reporters, and sometimes videotaped. Answers given during depositions can be used later in court proceedings or summary judgment motions. It is this possibility that has drawn attention from commentators such as Ben Meiselas, who has suggested that procedural maneuvers may be aimed at avoiding that stage. From a legal perspective, however, courts routinely allow defendants to challenge jurisdiction and sufficiency before discovery begins. This is not unusual. It is embedded within the structure of civil procedure. Beyond the immediate litigants, this case raises broader questions about the modern defamation landscape. Public figures often face a dilemma when confronting statements they believe are false. Filing suit invites discovery into personal and professional matters. Not filing suit risks allowing statements to circulate unchallenged. Threatening litigation without filing can also carry risks. If perceived as intimidation, such threats may trigger counterclaims or anti-SLAPP actions, as alleged here. The dynamic creates a strategic balancing act. Melania Trump's public role adds another layer. As a former First Lady, she occupies a space that is simultaneously political and personal. Commentary about her past social connections intersects with public interest and private reputation. The Epstein factor intensifies scrutiny. Jeffrey Epstein's crimes and associations have generated years of investigative reporting. His past connections to influential individuals continue to draw attention. In that environment, references to proximity, even historical and social, can ignite controversy. Legally, however, proximity is not equivalent to wrongdoing. Defamation law turns on falsity and intent, not on guilt by association. If this case proceeds, courts may need to parse carefully the difference between factual assertions, opinion, and rhetorical commentary. The Supreme Court has long distinguished between statements of fact, which can be defamatory if false, and statements of opinion, which are generally protected under the First Amendment. Context matters. Was the statement framed as a verifiable factual claim? Was it presented as speculation? Was it rhetorical hyperbole? These distinctions can determine the outcome of defamation disputes. Another significant factor is damages. Even if a statement is false, plaintiffs must show harm. For public figures, reputational harm must often be concrete and demonstrable. Courts scrutinize whether actual injury occurred or whether the claim is speculative. The reported figure of $1 billion in threatened damages underscores the magnitude of the reputational claim. But courts assess damages based on evidence, not rhetoric. The involvement of media commentary further complicates public perception. Political podcasts and digital media outlets amplify legal developments in real time. Interpretations spread quickly, often before judicial rulings clarify matters. This environment can blur lines between legal fact and political framing. Ben Meiselas's coverage reflects one interpretation, that procedural steps are tactical avoidance. Melania Trump's legal team would likely frame those same steps as standard defensive measures. The judiciary operates independently of those narratives. If the case survives dismissal and jurisdictional challenges, summary judgment could become the next battleground. At that stage, the court would evaluate whether sufficient evidence exists for a reasonable jury to find in favor of the plaintiff. Summary judgment motions often hinge on documentary evidence gathered during discovery. They can resolve cases without trial if no genuine dispute of material fact exists. If summary judgment is denied, the case could proceed toward trial. Trials in defamation cases involving public figures are rare but consequential. They involve jury evaluation of intent, falsity, and damages. They can last weeks and generate extensive media coverage. Settlement is another possibility. Many civil disputes resolve through negotiated agreements before trial. Settlements can include confidentiality provisions, clarifications, or monetary terms. However, when litigation involves public reputations and constitutional principles, settlement dynamics can become more complex. Another aspect worth noting is the broader pattern of defamation litigation involving political figures. Across the political spectrum, high-profile individuals have increasingly turned to courts to challenge media coverage. Some cases have resulted in significant settlements. Others have been dismissed at early stages. These cases contribute incrementally to evolving jurisprudence around public speech and accountability. In this dispute, the interplay between anti-SLAPP protections and federal procedural law will likely shape outcomes. Anti-SLAPP statutes are designed to deter lawsuits that aim to suppress speech. They often provide mechanisms for early dismissal and recovery of attorneys' fees if the suit is deemed retaliatory. Whether Wolff's claims meet the statutory criteria will depend on the specific language of the filings and judicial interpretation. Meanwhile, the procedural posture of the case continues to evolve. Court dockets reflect filings, responses, and replies. Judges issue orders setting briefing schedules. Oral arguments may be scheduled to clarify legal questions. Each filing becomes part of the public record. Observers tracking the case will look for signals in judicial language, whether skepticism toward jurisdictional claims, deference to venue arguments, or indications about the sufficiency of the complaint. Legal analysts often examine tone and precedent citations for clues about likely outcomes. The timeline of rulings can also affect momentum. A swift dismissal would close the matter quickly. Extended briefing and discovery disputes could stretch proceedings for months or longer. Throughout this process, the presumption of innocence and the presumption of lawful speech remain foundational principles. No court has determined wrongdoing in this matter. The litigation remains at a procedural stage. As motions are decided, the trajectory will become clearer. For now, the case stands as a vivid example of how legal strategy, constitutional protections, and political controversy intersect in modern America. It demonstrates that before facts are weighed, before testimony is heard, and before juries deliberate, the framework of the dispute itself must be established. Jurisdiction must be confirmed. Venue must be chosen. Claims must survive threshold scrutiny. Only then does the substantive conflict move forward. Until those decisions are rendered, the courtroom remains focused on procedural arguments. Arguments that may ultimately determine whether deeper questions are ever examined. The unfolding dispute underscores a broader reality. In high-profile litigation, the early motions often matter as much as the final verdict. And as this case continues through the judicial process, its impact will extend beyond the individuals involved, contributing to the ongoing evolution of defamation law, anti-SLAPP protections, and the boundaries of political speech in the United States. Throughout this unfolding legal battle, one reality remains constant. The earliest procedural rulings may determine whether the deeper questions are ever explored. If the court grants dismissal, the case could end without a single deposition. If jurisdiction is rejected, the venue shifts and the fight resets. If transfer is approved, the timeline changes. And if the case survives all early challenges, discovery could begin, bringing sworn testimony, document production, and a new phase of scrutiny. For now, the dispute between Melania Trump and Michael Wolff remains a procedural contest shaped by constitutional standards, anti-SLAPP protections, and federal jurisdiction rules. Commentary from figures like Ben Meiselas has amplified public interest, but the decisive moves will come from the bench, not the microphone. This case is a reminder that in high-profile litigation, what happens behind the scenes in legal filings often matters more than what trends online. And as the court weighs removal, transfer, dismissal, and the potential path toward discovery, the outcome could influence not only this dispute, but how public figures and journalists navigate defamation battles in the years ahead. Because when power, speech, and the courtroom collide, the next order signed by a judge can reshape the entire narrative overnight. Stay informed, watch the filings, follow the rulings, And if you want clear, fact-based breakdowns of the legal battles shaping our political landscape, make sure you subscribe so you don't miss what happens next. Because when power, speech, and the courtroom collide, the next order signed by a judge can reshape the entire narrative overnight.